Cornyn.
Mr. Chairman, if I could just respond to that point, because you're not giving the whole picture, sir. 90% of the documents we haven't seen. It's not the number of documents.
And I'll be glad to respond to that. But
we wouldn't
I-
hire an intern, sir, with only 90% of their resume.
Senator-
We're putting somebody
Senator
on the
Cornyn.
Supreme Court.
Senator Cornyn.
Thank you, Mr. Chairman. Judge Kavanaugh, welcome to you and your family and friends. I'm amazed at the poker faces I've seen on the front row during all of this pandemonium, unlike anything I've seen before in a confirmation hearing. In my view, it's not because your opponents don't know enough about you. It's because they do know all they need to know, apparently, to oppose your nomination. And even before you've had a chance to answer our questions, including their questions, many of them have made up their minds, but the American people have not been introduced to you before. This is an opportunity for all of us to engage in a question and answer format that will hopefully illuminate why it is so important to have judges who actually are tethered to the text of the laws passed by Congress, signed by the President, as well as the Constitution of the United States. The Senate Judiciary Committee undertakes few more important tasks than the one before us today. Last year, the committee considered and advanced the nomination of Justice Neil Gorsuch, who was just one of many outstanding judicial nominees by President Trump. This Congress has proudly confirmed not just Judge Gorsuch, but 26 judges to the appellate courts across the nation. This includes 3 outstanding Texans to the Fifth Circuit Court of Appeals. Historically, the confirmation of judges to our highest courts was somewhat routine. Justice Gorsuch was unanimously confirmed by a simple voice vote to the Court of Appeals. Not one senator voted against Justice Kennedy, who both you and Justice Gorsuch clerked for, and who you will succeed on the court. Not one senator voted against Justice Scalia's confirmation, who you have called a role model and a hero. But that was before judges were viewed as policymakers rather than fair and neutral interpreters of the Constitution and the laws drafted by Congress. Today, as I suggested, is a wonderful opportunity to re-examine the proper role for judges under our Constitution and the difference between legislators and judges. As Justice Gorsuch wrote before he joined the Supreme Court, upholding and enforcing this distinction between legislators and judges was the great project of the late Justice Scalia's career. Justice Scalia would always remind us that legislators may appeal to their own moral convictions and to claims about social utility, but judges instead should strive to apply the law as it is, looking to the text, structure, and history, not to decide cases based on their own moral convictions or the policy consequences. So this hearing is an outstanding way to remind the American people of the proper role of judges under our Constitution. Our Constitution provides for a federal government of limited and delegated powers with a Bill of Rights to further protect our individual liberties. To that end, the framers created 3 co-equal branches, as you know: the legislature to enact laws, the executive to enforce them, and the judicial branch to settle disputes about the meaning of those laws and the Constitution. Of course, the legislature could change the laws, but only an amendment can change the Constitution. For this reason, Alexander Hamilton wrote in the Federalist Papers. Mr. Chairman, could I pause there until the room is cleared?
Yeah.
Thank you. For this reason, Alexander Hamilton wrote in the Federalist Papers that the judiciary will always be the least dangerous branch because, as he famously wrote, judges would have neither force nor will, but merely judgment. Today, the Judiciary Committee has gathered to consider whether Judge Kavanaugh will honor that limited role for judges under our Constitution and whether he will properly exercise the modest and humble power of judgment entrusted to him under our Constitution. I'm confident the Senate will find that Judge Kavanaugh will faithfully and fairly interpret the Constitution and the laws of this great nation, and I look forward to him succeeding Justice Kennedy. One reason for that is because I've been acquainted with Judge Kavanaugh for about 18 years, and I can personally attest to his skills as a lawyer. When I was Attorney General of Texas, as the judge will recall, he helped me get ready for a Supreme Court argument. May I proceed, Mr. Chairman?
Yeah.
As I was saying, and when I was Attorney General of Texas, I had a chance to argue a couple of cases in front of the United States Supreme Court. One case Judge Kavanaugh helped me prepare for was one involving the question of school prayer at a high school football game at the Santa Fe Independent School District High School. After that, I was pleased to introduce Judge Kavanaugh to the Judiciary Committee when President Bush first nominated him to be a judge on the D.C. Circuit. What I said back then still stands the test of time today. Judge Kavanaugh has an unparalleled academic and professional record of service. Many will cite his education, his clerkships, his time arguing cases before the court, his experience working for the executive branch. But I think one of the most important factors to me is he's already exercised excellent judgment in marrying a Texan, Ashley from Abilene. So I know he's a good judge. In fact, Judge Kavanaugh is one of the most respected and thoughtful judges in the country. I am disappointed that despite his exemplary qualifications and outstanding record, so many of our colleagues across the aisle have announced their opposition even before he was nominated. The level of disingenuousness and hyperbole, even by today's standards, is extraordinary. Members from the other side of the aisle, including some who serve on this committee, have claimed that confirming Judge Kavanaugh would somehow be complicit in evil and the result in the destruction of the Constitution. Some have even claimed that you testified falsely. We've already heard that alluded to before the committee when you were serving our country in the Bush White House. I hope you'll have a chance to explain the apparent misunderstanding on the part of some senators. And I sincerely hope this week we can all take a deep breath. We're not doing very well so far. And get a grip and treat this process with the respect and gravity it demands. As others have alluded, the American Bar Association, which some have called the gold standard for judicial evaluations, have unanimously rated you as well qualified for service on the Supreme Court. And as we've heard, a number of lawyers and judges across the spectrum have talked about your qualifications and sung your praises. And I'm confident at the end of this hearing, your stellar credentials and your body of work as a judge will demonstrate that you properly understand the role of a judge under the Constitution. And I'm confident you will demonstrate that you will faithfully and fairly interpret the text of the law and the Constitution and dutifully apply them to the disputes that come before you. Finally, Judge, I expect we'll have a conversation or two about this book, which you contributed to, and the law of judicial precedent, because I know that there's a number of questions by members of the Senate about how you will regard previously decided cases in the Supreme Court. And I trust you'll give us a scholarly and detailed explanation of that and demonstrate that many of the concerns that have been expressed about a new justice coming on the court somehow wiping away previous decisions single-handedly, not even with the help of other members of the court, is just plain ridiculous. And we look forward to asking those questions and getting your answer. Thank you very much.
Senator Durbin.